The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right. Good afternoon. We have Mr. Boutros and Mr. Gupta. All right.
Yes, Your Honor.
We'll hear the case of Alig versus Quicken Loans, and we'll start with you, Mr. Boutros, and hear from you first.
Thank you, Judge Niemeyer, and may it please the court, Theodore Boutros. For appellants, I'd like to reserve 3 minutes for rebuttal. This court should reverse the $10 million class action judgment in this case because it's legally deficient in multiple ways. Seeking to avoid individualized issues and secure class certification, the plaintiffs convinced the district court below to adopt their radical interpretations of the West Virginia Consumer Credit and Protection Act and contract law almost verbatim. But now they've largely abandoned those legally baseless theories on appeal, and for good reason. As a matter of West Virginia law, in this court's decisions in cases like McFarland applying it, Quicken Loans' practice of including the borrower's estimate of the value of their home on the appraisal form was not an unconscionable practice that induced homeowners to do anything, much less cause them to enter into the loan refinance transactions at issue. Indeed, West Virginia law and the Uniform Standards of Professional Appraisal Practice, so-called USPAP, expressly authorized that practice during the class period, and there's no evidence, not a stitch in the record, that the plaintiffs were induced, that anyone was induced to do anything. And in fact, all the evidence is to the contrary. The only evidence in the record on this point is from Mr. Clark, an absent class member who opted out because he viewed himself as having been treated well. And this is at page 489 of the joint appendix. He said he would have consummated the transaction had he known that his own estimate of value was given to the appraiser. Plaintiffs themselves gave no testimony at all that they would have acted any differently had they known that that estimate of value was provided to the appraiser. I'd like to focus on 3 particular issues that we respectfully submit require reversal. First, as I mentioned, on the statutory consumer credit claim, it fails because as a matter of law, Quicken Loans engaged in no unconscionable conduct. During the class period, this practice of including the borrower's estimate of value on the appraisal form was indisputably expressly authorized by the USPAP standards, the Uniform Appraisal Standards. And West Virginia law, and plaintiffs do not even address this, West Virginia's statute that specifically, as this court said in McFarland, targets predatory lending, section 31-17-8, specifically incorporates those USPAP standards and says that lenders can rely on appraisals that conform to those standards that authorize the very conduct that's at the heart of this case. And I submit, Your Honors, that as a matter of law, one cannot deem something unconscionable that conforms to industry practice, uniform standards, and where the law of the state authorizes the conduct. That unconscionable conduct is conduct that's so over the top, that's so outrageous that it shocks the conscience, and clearly conduct that conforms to the law, that's authorized.
What state law did you say authorized the use of those standards?
It's the West Virginia Code section, Your Honor, section 31-17-8M8. This court cited it in the McFarland case, which I think is dispositive on the inducement portion of this, as the statute in West Virginia that specifically targets predatory lending. And that statute expressly says that, let me give you the quote, that it authorizes lenders to rely on appraisals, quote, prepared in compliance with the Uniform Appraisal Standards. So the law at the time incorporated those uniform standards that permitted this practice. And the district court nonetheless declared that that practice that West Virginia law authorized was per se unconscionable. And there was simply no basis for doing that, and then imposed this $10 million penalty retroactively for conduct that conformed to the law. And that's just pure error. And as this court well knows, the role of the district court was not to break new ground or declare something unconscionable or unlawful that the state statute.
I want to ask you a question,
Yes.
at least in terms of understanding where we are. It seems to me you are describing substantive unconscionability. That's not required under the West Virginia Consumer Protection Act. In fact, McFarland seems to indicate quite clearly that when you're dealing with unconscionability in terms of inducement, you don't need to show substantive unconscionability. And that the fact that the conduct is lawful, that's what the Consumer Protection Act is covering. That doesn't exonerate you just because it's lawful conduct you're doing. So isn't there a distinction here to be shown when you're dealing with unconscionability that's inducement as opposed to substantive unconscionability?
There definitely is, Your Honor, but here the practice that is supposed to be per se unconscionable was one that was authorized by state law. So it's not that the ultimate agreement was unconscionable substantively. That's not what I'm arguing. They claim that the practice of providing the borrower's estimate of value was unconscionable, and that practice, not the substance of it, but was so unfair that it is unconscionable. But we submit that if the practice is authorized by state law, if there's a green light to engage in it, it cannot be deemed unconscionable as a matter of law. And here the district judge did it as a matter of law per se. Yes, Judge Floyd.
What about the issue or allegation in the case about the inflated appraisals? Isn't that the unconscionable conduct we're talking about, or is it not?
It's not, Your Honor. That's what's just, if I may suggest, just ridiculous about this case. The claim is not, and there's no proof that the appraisals were inflated or unfair or biased in any way. And in fact, the appraisals, the experts all agreed on both sides. The plaintiff's own appraisers agreed that they were not influenced by the borrower's estimate of value. And the claim is not that anyone was actually injured. It was that the mere putting the estimate of value on the form was the unconscionable practice. And the plaintiffs themselves didn't testify that they wouldn't have gone forward with the transaction had they known that information was given to the appraiser. They don't claim that they were injured. They benefited from the transactions. They reduced their payments. They paid off debt. So this isn't a case where, like McFarland, where someone said that the appraisal was inflated and they relied on that and that they were injured. This is just, these words were on the form, and this is class-wide. The court held everybody gets to a $3,500 penalty, even if they weren't harmed, even if they benefited, and there's no testimony, not even from the named plaintiffs, saying, if I had known that, I would not have gone through with the transaction. And that brings me really to the inducement, unconscionable inducement. Because here, plaintiffs...
Tell me what you were just talking about then. I mean, my understanding, this case is about unconscionability from inducement. You said this brings me to it. What were you just talking about?
I was talking about there, Judge Wynn, the question of, is the conduct itself unconscionable as a matter of law? That's step one.
Well, the substantive, I think we made it clear that's not necessary. McFarland indicates that's not necessary to show substantive unconscionability. You've been talking about that the whole time. The question here goes to the inducement aspect of it from in terms of case law in West Virginia. And McFarland, while it may seem to, maybe you can clarify me, it looks like to me, this is a case that's really kind of gone a step further than McFarland in terms of the situation here. But give me your thoughts on inducement.
Yes, Your Honor, on inducement. So you have to have unconscionable conduct that caused, and this is what the court said in McFarland, proof that it caused the borrower to consummate the transaction. And that's what the White case says from the Virginia Supreme Court of Appeals as well. So here, where either the plaintiffs needed to prove that they were induced, and we all know what induce means. It means persuade you to do something, cause you to do something. That's what this court held in McFarland explicitly on this statute. And so the burden on the plaintiff was to put in evidence that either they relied on a specific misrepresentation. They claim there were misrepresentations on page 38 of their brief. They have no evidence of reliance. So that's prong one. Or that there was concealment of a material fact that had they known about it, they would have acted differently. They wouldn't have gone through with the transaction. There's absolutely not one whit of evidence. Plaintiffs don't even try to say there is. They claim that influence means, first they convinced the district judge that to read into the statute, Judge Wynn, that it's not just induced, but or furthered the transaction. Now I think Mr. Gupta has recognized that that's just rewriting the statute. But the plaintiff's now gone farther. They say it's just as long as something was part of the process. So anything that was part of the process, even if it had no effect on the borrower, even if nothing would have changed, is somehow inducement. And that's just, as a matter of law, Your Honors, incorrect, as a matter of plain meaning. And in McFarland, the court said, this court is not going to assume that the West Virginia Supreme Court of Appeals is going to adopt.
Do they have to prove reliance in this case?
They do not, Your Honor. To the extent they're relying on affirmative misrepresentations, which they say in their brief they do. They fail to do that. They don't even try. But we recognize that under the White case and under concealment cases, they could prove causation. And the White case that they rely on says that where it's concealment, then the requirement is to prove that the transaction would not have happened but for the concealed fact. Plaintiffs have manifestly failed to do that. They didn't even try. They did not put in any evidence, not even from the named plaintiffs, that the named plaintiffs, we don't have a declaration from a named plaintiff saying, if I had known that my own estimate of value had gone to the appraiser, I would not have gone through with the transaction. And in fact, just saying—
I thought White spoke of causality from the terms of as a result of.
Yes.
You mentioned the but-for causation. I don't know if I saw that language, but you know this better than I do. I thought it said as a result of.
That's what the statute said, Your Honor, but in interpreting as a result of, the court said that's a causation standard. And that's what McFarland held with respect to— this was a different prong of the Consumer Credit Act, but McFarland said they must prove causation, that it caused the unconscionable conduct, caused them to enter into the bargain. And here's what White said on page 837. It said, where concealment, suppression, or omission is alleged, and the causal connection between the deceptive act and the ascertainable loss is established by presentation of facts showing that the deceptive conduct was the proximate cause of the loss. In other words, the facts have to establish that but for the deceptive conduct or practice, a reasonable consumer would not have purchased the product or incurred the loss. And plaintiffs defaulted on that. They didn't even try. The plaintiffs themselves, named plaintiffs, did not put in any evidence of that. They put in no expert testimony that a reasonable consumer who provided their own estimate of value would have said, I'm not going to go through the deal now that I know that you gave it to the appraiser. And these appraisers, I need to emphasize this point. These appraisers have a professional obligation to act independently, to not be influenced by an estimate of value. They have to swear to that. But at least
in terms of Judge Floyd's question regarding reliance, if the allegation deals with concealment or some type of admission, when you do that, it seems to me that White makes it clear that you don't need reliance, and which goes to the question of, is there any need to inquire into the plaintiff's subjective mind in a case? But I'm looking straight at White in terms of it, and the question is, it wasn't required there to inquire into the subjective mind or how you would deal with a case of that type.
There would be various ways to prove. As I read the passage from White that said, when it's concealment, you still have to show but-for causation. And the plaintiffs, one would think, would at least have to say, well, I wouldn't have gone. They're representing a class. We don't know what any of the people, the thousands of people who are in the class, were even thinking or doing, whether they even were injured. But Judge Wynn, it's very clear from White, and this is similar to the fraudulent concealment context, there must be proof from the plaintiffs and then establishing that a consumer would have not gone forward with the transaction. As I mentioned, on this record, which, by the way, is a pretty extreme result. Summary judgment based on a per se finding of unconscionable inducement where there's no evidence from the plaintiffs themselves that they would have acted any differently or that they were even injured. But as I mentioned at the outset, Mr. Clark is the only sworn testimony in the record, and he said he would not have acted differently. And so there's no way this court can affirm this judgment, and it's a penalty.
It seems to me that from all the real estate transactions that I'm familiar with, the borrower would want their value to go to the appraisal so that the loan would be approved. In other words, they would almost wish for influence on the appraiser to follow what they thought was the value. But the appraisal is not for the borrower. The appraiser is for the bank or the lender. And the bank or the lender could even forego an appraisal and just make the loan based on cash flow or whatever other items they relied on. So it troubles me to conclude that these borrowers were induced to get into the transaction because of the failure to disclose something that was beneficial to the borrowers or would have been beneficial.
Exactly, Your Honor, and there's evidence in the record that borrowers would say to the appraisers when the appraisers would go to the house, my house is worth this and that, and they wanted them to know what the value was. The borrowers, after all, gave the estimate of value to Quicken Loans, presumably in good faith and honestly. And so you're absolutely right. I think that's why there's nothing in the record of a borrower saying they wouldn't have wanted that passed on.
Let me ask you on that point. I mean, that's very logical if we were talking about fraudulent concealment. We are talking about a Consumer Protection Act, which has a different goal and a whole different means of, a lot of times people may benefit from something, but the Protection Act has a whole different purpose in it and a different meaning of it. And when you look at language from Brown in particular, when you're dealing with a concealment type case, Brown speaks to the contribution of the formation of a conclusion in the plainest mind that is enough. And yet it is not required here to have fraudulent inducement. That's not required in order to be able to prove unconscionable inducement.
No, Your Honor, it's unconscionable inducement, and as this court in McFarland said, it's active concealment, and concealment of a material fact is in the statute now. So it's a species of concealment. And you mentioned Brown. I'm glad you did, because it emphasizes that unconscionable inducement is highly fact specific and depends on the facts of the particular individual's case. Here, we don't know anything about anybody else, and all we know is about the Allegs and the Shays that they weren't injured, that they wouldn't have acted any differently.
If we focus that this arises in a West Virginia law which deals with the Consumer Protection Act, the fact of benefit and harm doesn't really come into play in that act. I mean, that act protects certain conduct that can occur that may cause harm in a broader, I guess, in terms of the citizenry. So while, you may have individuals that benefited from it, but nonetheless, it does not sanction that an entity can nonetheless violate it because they say, well, they didn't get hurt by it. The fact that we went and gave inflated appraisals and gave them money far more than the value of their houses and stuff. They had extra money on it. That's exactly what the act is seeking to protect. It's not to say it's unlawful in some way. It's a Consumer Protection Act.
Your Honor,
first of all, I mean, when you think about it in terms of you got an appraiser that's supposed to be objective. And no one has said to these people that this thing is not objective. They're telling them, they actually, I guess at the end of the day, they think their house really is worth this because some appraiser has come back and said this.
Your Honor, well, the appraisers here all testified they weren't influenced by the estimate of value. There's no evidence of what the court just outlined, that these appraisals were not appropriate or inflated, or that the loans were any more than they were justified under the facts. And just one last factor, Your Honor, again, the consumer statute, this court held in McFarland, it requires proof causation of harm, of loss. Brown and White say there's a balance here. We don't want there to be cases where you're interfering with commerce and with transactions, and that's what this is. There's no injury. And Judge Wynn, it would be a different case if it was as you outlined it.
All right, thank you.
We'll did you have something further, Judge Wynn?
No.
Oh, okay. Why don't we pick you back up? You have a little bit of rebuttal. Mr. Gupta, it's your turn now.
Thank you. Please, the court, Deepak Gupta for the plaintiff's appellate. This case was first filed in West Virginia State Court in 2012. It came before this panel in 2013, and at that time, the issue was jurisdiction. Quicken fought to keep this case in federal court and indeed in Judge Bailey's courtroom. Now Quicken comes to this court on appeal and challenges virtually every aspect of the district court's management of this case over that period. But I think as the discussion so far has shown, the appeal really boils down to a threshold question on which the district court, as a federal district court sitting in diversity, was required to predict what the West Virginia Supreme Court of Appeals would conclude about the meaning of West Virginia's consumer protection statute. The district court did that, and it held correctly that Quicken's act of providing appraisals without disclosing the inherent unreliability was a misrepresentation, an omission that constituted unconscionable inducement under the statute. What Quicken is asking you to do is, I think, three things that should concern you. First, they're asking you to erect a rule of state substantive law that the state itself has not adopted, a requirement of reliance, an inquiry that turns on the subjective motivations of the consumer.
Mr. Gupta, I think that's a slippery slope. As I understood the argument, and I think we ought to face the argument made head on, one is that the conduct itself could not be characterized as unconscionable as a matter of law because of the arguments made. But I think the more substantive argument that the appellants are making, if I understand correctly, is the causation, that there's no evidence that they were induced. The word induced comes right from the statute, right. And that they were induced to go through with this transaction because of the omission. And the omission, what the White case described that, the nature of that causation. In other words, you need something to indicate that the plaintiffs wouldn't have gone through had that disclosure been made.
Right, Judge Niemeyer, I think you're correctly characterizing their argument.
So I just wanted to get you off the word reliance. In other words, I wanted to get you on causation. Yeah. We
can bracket off because the parties, there are a lot of disputes about the words, but I think you've correctly characterized the argument. The problem with that argument is it asks the wrong question and therefore gets the wrong answer. If in your formulation and in Mr. Boutros' formulation, the object of the sentence is the consumer, not the agreement. But the question under West Virginia law is whether the agreement has been induced. And if you look at the Brown versus Quicken Loans case that Judge Wynn was talking about, in that case, the practice was the same. The trial court there had held, and I'm going to quote you, that no legitimate purpose is served by providing an appraiser with an estimated value of a property. And then the case went up to the West Virginia Supreme Court of Appeals. Now, it's true that there were other practices at issue there, so I don't think that case squarely decides the issue before you. But as McFarland said, it comes pretty close. And what the court held there was, and I'm going to quote you now from McFarland at page 284, the court sustained findings of unconscionability in the inducement, and remember, it's the same practice, based entirely on conduct predating acceptance of the contract and allegations going to the fairness of the process. This is what Judge Wynn was talking about. It's not the result of the process and whether it's a substantively unconscionable agreement. It's whether the process itself has been skewed. And I think whatever you want to say about a mortgage transaction is integrally reliant on the appraisal. I'm sorry, Judge Floyd.
Let me ask you this. Even if the Quicken had no duty to disclose the inflated appraisals, assuming they were, aren't they required not to misrepresent the values that they did disclose?
Yes, exactly, Judge Floyd.
Is that what we're arguing about here?
Yeah, well, it's not just the values, it's the process. So they charged all of these consumers in the class for an independent appraisal. The whole point of an appraisal is that it's unbiased. The same West Virginia code that Mr. Boutros cited you that incorporates the uniform standards, it also makes it illegal to influence the appraisal process. And so the whole point is there has to be an appraisal. The appraisal is independent. That's obviously integral and material to the mortgage agreement. It's hard to think of something more integral to a mortgage than determining the price, the actual amount of the mortgage. And then the question under West Virginia law, and it's an objective question as a matter of law, is was that practice unconscionable? And what Judge Bailey concluded based on an extensive survey of cases from around the country and cases in West Virginia is that this is a universally condemned practice. Remember, in Brown versus Quicken Loans, which involved the same lender, the West Virginia court said there is no legitimate purpose served by this practice. And the reason that this practice is so condemned is because it skews the process. It results in higher values and can result in people being underwater. I do want to address a concern that Judge Niemeyer raised in a question to my colleague, because it's a question that I had in coming to this case, which is, well, if the borrowers might be the source of this number, what's the big deal? Because, you know, the borrower may want the number to be higher. But I think, you know, that's cold comfort. I mean, one of the reasons we got into the subprime mortgage crisis is because there were people who were eager to get into loans. They were eager to have the values be high. And we did away with appraisal and sound underwriting standards. And the result was that people were underwater. Those loans were sold to Wall Street. And the consumer protection statutes are certainly protecting the borrower from getting into a loan that is induced through a skewed process, but also protecting the integrity of the entire system. And so the West Virginia legislature passed this statute to protect consumers and to preserve the integrity of the mortgage process. And I think this court's job is, as a court sitting in diversity, is not to erect new rules that make it harder for consumers to prove these claims. This court's job is to predict what the West Virginia Supreme Court of Appeals would do. And I think you can do that modestly here. I think you can take a cue from McFarland. In McFarland, the court said, we're not going to determine the parameters of this claim or the outer boundaries of the claim. But I think what you can do is if you take McFarland together with Brown versus Quicken Loans, I think you can narrowly affirm without creating any new law. And all you have to do is adhere to McFarland's holding. I'm sorry, Judge Floyd.
I want to ask you a question about the restitution. Has West Virginia ever held that restitution is an appropriate remedy for a breach of contract claim? And if they haven't, why should we do so now?
Well, I think, Judge Floyd, in candor, there is no West Virginia Supreme Court of Appeals case that is directly on point. I don't think either party has pointed you to one. And so what we have said is that Virginia relies on the restatement of contracts, and that is certainly codified. And what the district court applied here is just the standard traditional restatement rule, which is that a person must pay restitution, must pay an amount equal to the benefit conferred on him. That's restatement second of contracts 371. And if the benefit consists simply of a sum of money received by the party from whom the restitution is sought, there's no difficulty in determining that amount. And that's a quotation from the restatement. I would point you to the Realmark case from the West Virginia Supreme Court, which is on page 55 of our brief, that shows how West Virginia courts measure restitution. But I do think it is not a question that the Supreme Court of Appeals has squarely confronted. I think the restatement traditional approach, which is shared by courts around the country, is the right one. I also think it's just worth talking about what the facts of this case are. I mean, this is a case where they charged each of these people $350 for a skewed appraisal that was not independent. And all the district court said is you get your $350 back. If you adopt, I'm not quite sure what Mr. Boutros is suggesting the methodology should be for calculating restitution, but certainly something more complicated than that. And I just don't know how one would calculate it or what source of law one would rely on. So I think
your colleague said that West Virginia had essentially incorporated the uniform standards for appraisal practice, and therefore made this practice of getting the homeowners to give appraisals, made all that legal. Do you agree with that?
Absolutely not. Thank you for asking me about that. I meant to turn to it. I'm really puzzled by that argument. He's correct that the West Virginia Code incorporates those standards, but nowhere do those standards authorize lenders to provide the estimated number for the borrower. In fact, I think the district court found that Quicken's practices were at odds with the uniform standards and that this is a universally condemned practice. So if anything, the relevant provision of the code to which Mr. Boutros is pointing is subsection M2, which prohibits lenders from seeking to influence the appraisal process. And I think, to the extent you're trying to figure out what is the substantive policy of the state of West Virginia, that's a clue. But I think an even better clue is what the West Virginia courts have said in a case involving this same defendant and this same practice. And if the court has no further questions.
I do. I seem to recall there is an exact provision that authorizes the borrower to submit the appraisal value to the appraiser, so long as the appraiser doesn't agree to follow it and exercises independent judgment.
There's no such provision
in the standards.
There's no such provision in West Virginia law.
I said in the standards. Let's start with a question. My question was, in the standards applicable.
I think that there's a confusion about whether...
Do you have that before you, sir?
I don't have that provision before me, no.
All right, that's what I'm asking.
Yeah, and I think there's a confusion about what the standards impose on the appraiser and what is imposed on the lender. And I think that the district court addressed this in some detail.
Mr. Kopka, if you would answer my question, I'm trying to find out what the established practice was at the time this conduct occurred. And as I recall, the practice followed was exactly as that authorized. Now you're saying that isn't so, I can check it. But I'd like to have you address that and not some other argument.
Right. Well, Judge Niemeyer, I'm trying to, and I think the district court went into this in great detail in its decision on June 2016. And one of the defendants here, one of the appraisers, Dewey Gouda, who was the same appraiser in the Brown case, actually conceded. He surrendered his appraisal license. He said Quicken was regularly attempting to influence his appraisals. He was found to have violated the uniform standards. And he went on to characterize the providing of the owner's estimated value as a tip-off. So I think the district court went through this in great detail. This was a uniformly condemned practice, and you don't have to take our word for it. You can take the word of the West Virginia courts in the Quicken Loans versus Brown case. Thank you.
All right.
Excuse me. I had another question. Give me your response. Your colleague had mentioned that there was no proof of harm in this case because of no deposition testimony that plaintiffs would have entered these loans had they known of this process. How do you respond to that?
So I think my first response is just to say, in terms of the counterfactual question of what plaintiffs would have done, that's not the right question because it turns on subjective expectations. But certainly there was harm in the form of, the amounts that were charged. There's harm in the skewing of the process. And there was also actual damages. I mean, that's not before you in this appeal, but the ALIGs were underwater. There were other people for whom there was consequential harm, and there was a process for dealing with that. The question before you, though, is about whether or not the district court was correct in assessing statutory damages for a class-wide practice that skewed the integrity of the system. And so for that kind of claim, you don't enter into an individualized inquiry is a consequential fact. If you did that, of course, you couldn't decide it as a matter of law, and you couldn't have class actions.
Are you relying on the district court's idea of this per se unconscionability?
When I think when the district court says per se, I think the best way to read that is just that the district court made a finding ultimately as a matter of law. The West Virginia Supreme Court of Appeals has been clear that this is a question of law. It is, of course, informed by the factual context in which it arises, but it's ultimately a conclusion of law. And in Brown versus Quicken Loans, the West Virginia court made the unconscionable inducement finding as a matter of law, and the Supreme Court of Appeals affirmed it.
I'd like to go back to Judge Niemeyer's question and follow up. He quoted to you what the standards were, and they say they followed those standards. Then you say that it's universally condemned. I mean, how do we reconcile those two things?
I think Quicken is arguing, I think what they're arguing, this is not something that they focused on very much in their brief, but I think what I heard Mr. Boutros arguing is that the standards somehow expressly authorize that practice. I think that's not correct. At best, you could say that the standards don't expressly address and forbid this practice, but Quicken is ignoring the fact, this is what I was trying to say to Judge Niemeyer, ignoring the fact that those standards do not apply to lenders. Lending standards regarding appraiser independence are separate and stronger than the standards set by the appraisal.
Well, let me try again, Mr. Gopka. I'm now taking this information from your colleague's brief, but he's quoting the actual standard. He says, the standard expressly permits appraisers to accept assignments in which lenders provided an, quote, owner's estimate of value, close quote, or even an, open quote, approximate or minimum value needed, close quote, so long as reaching those values is not, open quote, a condition of the assignment, period, close quote.
Right.
Is that the text of the standard?
Yeah, I think you've read it, but I think what I'm trying to say is
I'm asking you, sir, don't duck the question, is that the text?
Yes, I believe so.
All right.
I believe the district court addressed this at Joint Appendix page 398. And what the district court held is the same thing I'm saying, which is those are not the standards that are applicable to Quicken. The standards that are applicable to Quicken are the lending standards. Quicken is a lender. And so the question is it permissible for the
This was a standard of appraisers receiving the value of the house from the owner. Right. And the practice says that can be done so long as the appraiser exercises independent judgment. And that's all I'm trying to get from you. And if that's so, that was an accepted practice at the time.
No, incorrect, Judge Niemeyer. I think the conclusion does not follow from the premise. And I think the district court addressed this in some detail.
Why don't you leave the district court alone and just make the argument why it isn't?
Sure. Because the standards that are applicable to the lender are more.
This is not to the lender. This is an appraisal standard.
Correct.
This is a standard applicable to appraisers. Correct. And provides the ethics appraisers that provide. And Correct. It says appraisers may receive that value from the owner.
The defendant here is not an appraiser, Judge Niemeyer. The defendant here is a lender. And
sir, will you address my question? We're talking about a question of whether the appraisers acted unethically. And the practice that the appraisers followed at this time was consistent with the appraisal standards.
No, I think that's wrong, Judge Niemeyer. That's the wrong question. The question is whether or not...
I'm asking you that question. I'm not asking what the right question is. You can argue however you wish, but I'm asking you, did the appraisal standards authorize appraisers to receive the values from the homeowners? And so long as they exercised independent judgment. And that's all I'm asking. And you don't seem to want to acknowledge.
I've answered that question a few times, I think.
Why don't you just answer Judge Niemeyer's question and say yes as to what he is saying? Yes, he is correct.
Judge Wayne.
But there's a but to that. There's a but to that.
So, Judge Niemeyer,
that the appraiser is not the defendant here. What you are dealing with here is the lender. That yes, that may be true for the appraiser could do it, but the lender is the one who's doing this. And that's the distinction that the district court made. And yes, he is correct. Read it all day long. It's exactly what it says. But it doesn't apply to this case because that's not the defendant here. It just says that if an appraiser can do it, yeah, that protects appraisers from doing it, and they change the practice on it. So I think what you're saying is it's not forbidden, but that doesn't mean that it's permitted.
That's correct. That's correct. And more importantly, the practice at issue here, which is I think what you're saying, the practice here is skewing the appraisal process by the lender providing that number. And there's no question.
As long as we focus on the lender, we're okay. But if he was suing the appraiser, we'd be in a different ballgame.
That's right.
How much money the appraiser got? You're probably not going to sue him too much, because. I'm just.
That's right. No, they dropped out of the case. They were defendants earlier, but they're no longer defendants here. If there are no further questions, I'm happy to conclude. Thank you.
All right. Thank you very much, Mr. Boutros.
Let me just pick up on this point that Judge Wynn was making. The lender, the statute in West Virginia, Section 31-17-8, explicitly says that the lender may rely on an appraisal of the property, and I'm quoting, by an independent third-party appraiser duly licensed in West Virginia and prepared.
And that's exactly correct. I think you're correct. I think we can all agree to that. Here's the problem.
I'm not done, Your Honor.
The lender, but hold it before you do. I'm just saying, here's the problem. Here's the focus. He can rely on it, but the problem is he's a party to doing it. He's the one that's getting it. The lender's the one that's getting the overvalue, giving it to the appraiser, and then even when the appraiser doesn't come back the way he wants it, they've got a little scheme where they go back and says, "Oh well, you can go up a little higher, you can do a little bit," and they keep ratcheting it up. If we were talking, the appraisers are out of it.
Your Honor, first of all, let me read the definitive part that completely refutes Mr. Gupta's argument and respectfully what Your Honor just said. It says an appraisal based on the uniform standards, which authorize the appraiser to consider the borrower's estimate of value as long as they act independently.
I'm conceding everything to you on that. I don't think that's a
then you should reverse.
Of what I'm saying.
Then you should reverse.
But listen what I'm saying. We're not talking about that appraisal per se. We're talking about the actions of the lender.
Correct, Your Honor.
And there's use that as a shield. He can't use that as a shield that says, "Hey, they can do it, so let's go and do it ourselves and get this up here and then give it to them." They're the ones pushing it. They're the ones who are being sued.
Your Honor, there's no evidence whatsoever of that in the record. That's a completely different case, Your Honor. The only practice at issue
defendants,
here.
Well, let me ask you. Let me just ask one.
Yes.
Who are the defendants in this case? Are the
defendants
appraisers the defendant? Are the appraisers the defendant? That's
the defendants are the. It is the end of it, and you should reverse, Your Honor, because the only practice at issue, it's not inflated appraisals. There's no evidence that the appraisals were skewed. Look, scour the record, Judge Wynn. You will not find a
So tell me, why did we remand in McFarland? If what you were saying, why wasn't that the law in McFarland?
Because McFarland said there had to be proof of causation. And even if the proof here would need to be that the borrowers were induced.
What was the conduct in McFarland? Wasn't it the same thing?
No, not at all, Your Honor. There it was an inflated appraisal. The appraisal was $200,000 for a house that was worth less. This is not about. That's why I think, Your Honor, go back and look. This is not about inflated appraisals. There's no evidence the appraisals were skewed. It's all the only practice, Judge Wynn. The only practice is putting the estimate of value on the appraisal order form. We don't even know if the appraisers saw that. There's evidence that they didn't. This is a class action. This court can't affirm a $10 million punishment. It would violate due process where there's no evidence that any of the appraisals were anything but accurate. All the appraisers here, Your Honor, said that they were not affected and that they were following the standards. So, Your Honor, I grant you the case you're describing would be a much different case. That was McFarland.
The good news is that, we have what you're saying, and I'm going to accept what you're saying, but I will tell you, the facts will bear it out. And the question will be, are those the facts in this case here? If they're just as straight up as what you're saying, they'll bear that out. But if they're not,
absolutely,
it's not going to come out that way. And I think McFarland informs this. And I believe if your theory was correct, we would have dismissed McFarland.
No, Your Honor, I think that if you follow McFarland and apply it to the undisputed facts here as I've described them, which is absolutely accurate, and Mr. Gupta's description is a completely different case. This isn't a subprime mortgage case, has nothing to do with any of that. So I'm willing to bank on my version of the record. And if the court looks at the record and looks at McFarland, by the way, the Brown case
no need
had
to
nothing
do that.
to
We
do.
got the record. The record is already set. There's no need to bet on the record. It'll be right there in front of us. We'll go through it, okay?
I trust you will, Your Honor. Thank you very much.
Thank you. All right, let's call it an end here.
Thank you for hearing us.
I think we've heard all the points, and they're all well taken, and we'll consider them. Our practice, as you know, is now to heal all wounds, come off the bench, and greet counsel heartily, and we do so. And we do so virtually. We can't come off the bench in this case. We'll resume that practice when we're allowed to, and we hope the two of you come back and we can repeat. But thank you very much for your arguments. They're well argued, and you held your points, and we'll get back to you.
Thank you, Your Honors.
Okay, we'll take a short recess, stand adjourned, and then resume for our next case.
Thank you.
The court will take a brief break before hearing the next case. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, thank you. We'll hear the next case, Clayland Farm Enterprises versus Talbot County. And representing Clayland Farms, Mr. Gabler, you can begin.
Yes, Your Honor, thank you. Mark Gabler, may it please the court. Good afternoon, it's a pleasure to be here with you today. We are here appealing the grant of summary judgment by Judge Russell of the U.S. District Court against Clayland Farm on the federal and state takings claims that were made in our complaint, as well as the substantive due process claims. Judge Russell also dismiss some of these state law declaratory judgment and injunctive relief claims based on mootness, and I'd like to address those briefly in that order. Let me start by mentioning there are two basic complaints that we've made about Talbot County and the things they've done to Cleveland Farm that have impacted Cleveland Farm, and those involve the moratorium, development moratorium, as well as the improper tier map designation. And I preface that by saying, judges, I've read at least some of the cases in this area, and I've seen various references to the court's reluctance to wade into these kinds of local land use disputes. And I would just remind the court, as I'm sure you know, that both of our complaints, which were now ultimately consolidated, were filed in state court and ultimately removed to federal court. In this case, Talbot County imposed a moratorium that began in the year 2012. And that was a moratorium that ultimately lasted 6 years and prevented landowners with properties in the village center zoning districts from pursuing any development other than a single lot. The purpose of that moratorium was not to address any specific exigency or emergency. It was simply to prevent village center properties from being subdivided or developed until at some point in the future when the county could complete its comprehensive plan and comprehensive rezoning process. Ultimately, that was completed in 2018, and the moratorium was then terminated. In the case of Cleveland Farm,
before, as you're getting into it on the substantive due process, you have to establish at least some type of protected property right here, and I'm trying to determine what is that right that you say you have?
Well, I would tell you that there were a number of rights that we had before the moratorium was put into place. This property was zoned village center, capable of being developed with residential development at 4 units per acre. We had water and sewer service under an existing service. We had an S1 designation and a connector line adjacent to the property. We had consistency with the comp plan and all the various indicias of development we had. And
how do you distinguish it from the Sienna Court case? That was a case you had that was the storage building up there, and the court said, I guess like here, there was no permit that's been issued and no construction and anything there, and says, well, that's not there.
Well, I distinguish it on several grounds. First of all, that was more of a vested rights analysis in that case. And our case would be similar to that if there was never a moratorium that was put in place, in our view, unlawfully by the county. So in 2012, the county said, no development, no subdivision of this parcel and other parcels in village center districts. And that prevented our client from moving forward with obtaining.
I'm just trying to get to the heart of it, and because I think this is key, at least from my perspective, and that is, you mentioned some designations, the sewer status and things like that. Do they just last forever? I mean, it seems like to me you're claiming a constitutionally protected right for designations, and they just stay there.
Well, they stay there until they're properly changed, Ron. And properly changed does not mean any legal moratorium that's not designated to address any specific purpose or exigency.
But what affirmative things did your clients do? I'm thinking of the designation, the S1 or whatever designation there, the sewage one, and others. Those were really governmental type things. Did you mention they had done something to the property along getting a permit or doing something like construction or something like that?
They had previously subdivided 6 lots from the property in 1991 or an earlier date like that. But once the moratorium was put in place, there was nothing.
When was the moratorium put in place?
There was an initial resolution in 2011, and then there was a bill passed.
So in 1991, they subdivided some property into 6, and I guess this was their parents.
Yes,
is that right? Okay, yes. The parents did that, and 2011, you didn't have a moratorium, and you're saying there's a constitutionally protected right that derives from dividing up into 6 lots back in 1991?
No, what I'm saying to you is that once the zoning is conferred to our clients and to this property, the county is not able to just change that zoning at their whim or at their, whenever they choose to, unless they go through the proper process, which is a comprehensive planning process.
When did the corporation come into existence? That's, I guess, what I'm trying to get at. You told me what the parents did. I'm not sure does that really apply? I mean, isn't it what's happening with the corporation? When did the corporation come into existence?
Your Honor, I don't have the specific date in front of me. I'll try to find it while I'm continuing the argument. But this was a family-owned corporation that was started, I believe, by Miss Bryan and her brother.
I know what it is. I'm just trying to understand in terms of what the protected right here and what occurred with regard to this corporation that's asserting this constitutionally protected right.
What occurred was that in 2012, the county placed a moratorium on any further subdivision or development. So there was nothing that Clayland Farm could have done to pursue their rights. And that moratorium, under all of the cases that we have cited in our brief, was at least, if nothing more, illegal. At a minimum, it was arbitrary and unreasonable because it wasn't designed to do anything other than.
What did you done up until that time? Up until 2012, I thought you had put the land in, or your client had put the land in an agricultural circumstance for a tax benefit, and never sought any development rights. And it seems to me that even as of today, they haven't. And the question that Judge Wynn is asking is to focus in on what is the right that you're trying to protect with substantive due process.
The right is the property interest we have in the zoning classification of the property. We cited the EJS Properties case versus City of Toledo. That's a Sixth Circuit decision. We've also cited Washawleski versus Winston out of the Fourth Circuit. We believe that once the county confers the benefit of zoning, the zoning stays until the county pursues a proper procedure to change the zoning.
Do you have a case that says a zoning is a protected right?
The case I just cited, Your Honor, property owners may have a property interest in the existing zoning classification for their property. Property owners similarly have an interest in a discretionary benefit, such as a rezoning ordinance, after it is conferred. In this case, the property in question, the Clayland Farm property, had the village center zoning for many years. And if the county, rather than imposing an unlawful moratorium in 2012, would have started the comprehensive plan process followed by the comprehensive rezoning process, our client would have had at least 6 years to pursue a subdivision approval and potentially vest their rights in the zoning to prevent it from being downzoned. So in this particular case, what the county did was they imposed a moratorium for no stated purpose, just because they ultimately pre-decided that they were going to downzone this property. And that moratorium prevented our client from securing any rights, and we had to sit there and be the victim of this downzone. We filed this lawsuit, we were removed to federal court, we filed a second lawsuit, we got removed to federal court again, and here we are.
What steps has Clayland, the corporation or the LLC, what steps has it taken at any time since its existence? I think it came into existence around 2002, but
I think you're probably right, Your Honor. Thank you.
At any time since its existence, what steps had it taken to pursue development? What plans? Is there any drawing or plan or letter or description of a plan or development plan, application, anything to disclose that they wanted to do anything?
Your Honor, there is a sketch plan, and to be honest with you, I don't know where or if that's in the joint appendix. But the truth is that when this moratorium was adopted, that prevented them from doing anything. That said, no more development, no more subdivision, that's it. And so at that point, there was nothing.
Well, you had 10 years from 2002 until 2012. The property had been subdivided, and you did nothing. You didn't even develop a plan.
Well, they were farming the property, Your Honor, and they had every intention, as Ms. Bryan testified.
What's the evidence of that? I'd like to see. I looked for it. I didn't see any letter to the county, any application, any indication of intent.
Your Honor, she testified without refute. No one disputed her testimony in her deposition that they had intended to develop this property in the future. They were relying upon the value in that property to use for college, for their children, or whatever it may be in the future. And then that right is taken away from them as if it never existed. And the county is supposed to go through a process that involves the public notice, public comments, etc. And our client could have, at that point in time, if this moratorium was not in place, could have presented an application, could have pursued the matter to get her subdivision approval long before the property was ever downzoned. So this was a preemptive strike by the county. It was a moratorium that took
let me just, I think what we're trying to understand, and maybe this is where we're running to a brick wall, so to speak, on this, but just to be clear, you can have a vested right in an existing zoning act. I mean, that's established. You can have that. But there's Maryland case law, this Maryland reclamation case is one on point that says that, well, if you're going to have that, the owner must have done something, must initially obtain a valid permit and begin construction. And in this case, nothing was done. And, there's no permit, there's no construction. Yeah, you got a zoning right, but it doesn't last forever if you do nothing.
I agree with that, Your Honor, but the reason, I don't disagree with what the court is saying. The reason nothing was done is because the county put a moratorium in place saying nothing could be done. So if, in fact, there was no moratorium and the county went through the appropriate comp rezoning process, comp planning, comp rezoning process, and changed the zoning of our client's property without us having vested our rights, that would be a different issue. In this case, in order to make
that statement seems to suggest when the moratorium was put in place in 2012 that you had something planned and ready to go. Let's say you didn't get a permit, but you had some kind of plan, some kind of drawings, and the moratorium interrupted you. But the record's devoid of that.
Your Honor, my client was not anticipating the county depriving her or taking away all of the development rights that existed on the property. It's not something that she has to pursue in order to have this value to have been taken from her. This moratorium has no basis in fact or law. All of the cases on moratorium say there has to be some focused purpose, some exigency that the moratorium is addressing. In this case, it was just, we don't want them to beat us to the punch. We don't want anybody to secure their rights before we can downzone them. And it took 6 years. These property owners should be entitled to rely upon the zoning that they have, pursue development and use of their property based on the existing zoning until it is properly changed.
You could have done something with the 6 properties, couldn't you?
Yes. And
you had 6 parcels that were subdivided. Did you do anything with those?
We can.
Did you do anything with them?
No, we've not built on them, Your Honor. No.
Have you made any plans or applications to build on them?
Not at present, Your Honor. No.
At any time up to now?
No, we had them subdivided. Right. That's all we've done. Right now, we're trying to figure out, how to deal with this situation with the county putting us on hold through this moratorium and then imposing this downzoning on the property. We're not arguing that the county.
Why didn't you challenge the moratorium when it was first imposed upon you? And then say in your challenge that, we've got plans to do this and do that. And you're infringing on that right. But you sat on your hands for 6 years.
No, Your Honor. We filed this lawsuit in 2014. So we filed it about a year and a few months after the moratorium was put in place. So we pursued it pretty quickly.
And so what did you tell the court when you filed your suit? What were your plans? That's what Judge Niemeyer and Judge Wynn trying to get that out of you.
Your Honor, we didn't.
That goes to the substantive due process claim.
We did not develop a specific plan prior to the moratorium. When Ms. Bryan came to us and we met with her about the moratorium, we explained there's no use in spending $20,000 on an engineer to prepare a plan. The county has imposed a moratorium. So we filed a lawsuit to challenge the moratorium. Initially, we didn't have success, and Judge Motz in the district court said that our claims weren't right. We went up on appeal and were before your court in 2016. That was sent back, and now here we are again saying some of the claims are moot. So, we're just trying to get the court to understand that this moratorium is the crux of the issue. And that is what prevented our client from securing her rights and preventing me from telling you this is what she has done in the interim. So I would like to reserve my remaining few minutes for my rebuttal.
All right. Thank you.
Thank you.
Ms. Shearer?
Thank you, Your Honor. I'm not sure what happened, but somehow I was muted. Victoria Shearer on behalf of the Talbot County appellee, and may it please the court.
Could you speak up just a bit?
Of course.
Or get your microphone closer or something.
Yeah. Okay. So our first argument is that the plaintiff lacks a protected property interest to support the constitutional claims for substantive due process and taking, and we did cite the Washbolewski case, or however you pronounce that. So
he says he has a vested right because of zoning, and that he was already in the process of, had some plans of thinking about it, and then all of a sudden you come along and put a moratorium on in 2012 and lock this property up for 6 years. They couldn't do anything.
that's not supported by the record one bit. That is absolutely false. This property had no plan, no application. There is no sketch plan that was made before the moratorium was enacted. And Maryland is a vested rights state, as I'm sure you're aware. As you said, you have to have a valid building permit, and you have to perform substantial construction based upon that valid building permit in order to have a vested right against a change in zoning of your property. They don't even challenge the zoning change in this case. They're challenging the interim density regulations or moratoria of bills 1214 and 1257 that were first enacted in 2012.
Do they have the effect of being a zoning change? When you put a moratorium, does it kind of have the same effect?
No, Your Honor.
Do we in any way treat it similarly?
You do not, and there's a good reason. Moratoria are essential, useful land use tools, as the Supreme Court explained in Tahoe Sierra when they upheld them and said that they're lawful. You do not have to have an exigency, as Mr. Gabler claimed. That is not the law. The law enables local jurisdictions to maintain the status quo and put a hold on density and development while they strategize and plan, so that was the process that was ongoing while the moratoria were in effect.
Well, Ms. Shearer, why did it take 6 years? I mean, why 6 years?
Thank you, Your Honor. I was just going to get to that. What happened is that it didn't take 6 years. It took 4 years for the county to enact the 2016 comprehensive plan, okay? And it took that long in part because of this case being filed, and also largely because of state changes to its legislation, and because of the comprehensive nature of what goes into a comprehensive plan, especially for a county like Talbot County. Talbot County's western villages in particular are completely surrounded by water. Those waters flow into the Chesapeake Bay. There are extreme comprehensive state regulations protecting the Chesapeake Bay, and they require local jurisdictions to go through a certain process that is cumbersome and time-consuming. There's absolutely no evidence, on the other hand, in this case, that the county delayed in any way, or that they intentionally delayed, or that it took longer than it should have taken for the comprehensive plan to be enacted. There are public hearings. There are planning staff, zoning staff. there is public input. There is input by public agencies. For instance, the Maryland Department of Planning, which was originally sued in this case, has to comment on all of this legislation. Also, Talbot County has a large critical area under the Critical Areas Commission and that legislation enacted by the state. And in fact, Playland's property is almost entirely critical area, which is why it was rezoned to a resource conservation zone and taken out of the VC zone during the comprehensive plan. So to specifically answer your question, however, the comprehensive plan was adopted in 2016, so that's a total of 4 years. Then the county had to go through a competitive bidding process to hire a company that would redraft the zoning regulations based on the comprehensive plan. State law in the environmental article requires that the new rezoning be consistent with the comprehensive plan. And so once that company was hired, that company had to ensure that that occurred. They had to come up with an original draft that was then reviewed by the county attorney, by the county council, went back to that company. It was reviewed by planning staff, by zoning staff, and comments were made. And it had to be finally revised and acted upon by the county council to adopt the rezoning changes and the maps that went with it. And so that all.
But you're giving a very good comprehensive explanation, and I got to believe the trial court heard just as much or more than we did. And the trial court was concerned about the 6 years, but nonetheless, work with it. But he was definitely concerned about it. But I do have a question, and that is, your opponent indicated that the parents subdivided this property back in 1991. They had bought it, and can we or should we credit those actions to this corporation that's in privy, in some kind of privy with them, or do we look at that as the distinct type action?
So the Darby Farm subdivision was approved in 1991 by the county, and it could be built at any time. The campers chose not to develop it, and it has been sitting there unused all of these years. When the campers had both passed away, the children, which are Gene Bryan and Mr. Camper, forget his first name, I'm sorry, they inherited it, and they were 50-50 owners of the property from that point forward. In 2002, they incorporated, forming Playland LLC in order to move forward under, I guess, to protect themselves from liability and tax liabilities. But the point is that in the articles of incorporation for the LLC, there's mention of farming, there's mention of residential leases to tenants who are living on the property, but there's absolutely no mention of any intent to residentially subdivide the property or develop it. And so for Gene Bryan to say the intent was to residentially develop the property in the future, she was talking about her grandchildren. She was talking about her desire to maintain the VC zoning of the property in perpetuity. She did not want the county to be in a position to be able to downzone her property. I guess she saw the writing on the wall. She saw the political climate. She guessed that her property would be downzoned based on all of these factors. And so she filed this lawsuit to interfere with the process and prevent that from happening. But she never actually, the strange thing here is that plaintiff never has amended the complaint to actually challenge the new rezoning. So this case is not about her zone or any development rights whatsoever, because Playland has none. Playland has no vested rights.
Is there any scenario under which Clayland Farm Enterprises could bring a regulatory takings action if it didn't have a constitutionally protected right interest for due process purposes?
The way I've read Washlewski case in particular, you have to have a property interest to support a takings claim or any constitutional claim. You have to have that property interest under state law. And Maryland is a vested rights state, and there's really no other bases other than vested rights. I mean, if you're not challenging the zoning, then the question becomes, what is the property right here? And the only property right that could exist to support the takings or this substantive due process claim is if they had submitted an application before the moratorium was enacted, or if
what happened in the case of Pulte, where you had where the court did go and conducted the Penn Central type analysis, even after it found that the plaintiff had not been deprived of any constitutionally protected property.
That's correct.
What? Go ahead.
Sorry, let me cut you off. We did go ahead and do that, and they assumed the hypothetical 83% diminution of value in the property caused by the changes that were made by the Montgomery County Planning Board to its master plan. And the court there, consistent with all of the other Fourth Circuit case law, held that even if there's an 83% diminution in value, that's insufficient to support a taking claim. And so there were other cases where the diminution in value had been as high as 92.5%, and the court still said that was insufficient to support a takings claim. And so, you know, and Pulte had also invested millions of dollars and lots of time. The county had ignored them for 5 years, which really was a de facto moratoria. And yet the court said, nope, there's no property interest here. And even if there were a property interest, there's no regulatory taking and there's no due process violation. And in fact, here the Pulte court actually said, this court said in Pulte, I should say, that if you don't have a due process violation, then you can't say that you have a regulatory taking. And so they had cited to Quinn and to Sylvia, and there's also the state case of Neifert versus Maryland Department of the Environment, where the court had held that there's no constitutional right to sewer service. And they had gone on and on, citing to all of the recent case law by this court, stating that these types of restrictions and the effect they have are not unconstitutional and they do not constitute a taking. But going back to the purposes for the interim density regulations themselves, which are what is challenged here, they were put in place under the authority of the Supreme Court's decision in Tahoe Sierra. The court there clearly indicated that limitations on the density of development that are intended to maintain and preserve the status quo while this type of comprehensive replanning and rezoning goes on are entirely legal. And that's what is at issue here. And it's like you said, Judge Nguyen, the district courts seem to take pause in the third element of the Penn Central analysis when it said that it questioned the duration and the reasons given by the county for the duration of the moratorium. And while I understand the district court's concern, I have to respectfully disagree. And I think that the district court misunderstood the change in state law and how it was handled by the county when they said, we're gonna change comprehensive plan being due every 6 years and make that 10 years. The court seems to believe that the county had somehow delayed because they could have finished it sooner, or seemed to believe that the change in the law gave them plenty of time and yet they didn't do it. I'm really not sure what Judge Russell was thinking, but it's actually the opposite reason that law was changed. That law was changed because local jurisdictions having to re-plan comprehensively every 6 years was impossible. As soon as they finished one comprehensive plan cycle, they'd be right back at the beginning of another one. They just couldn't do it. It takes too long, it takes too much time. They have limited staff, and the process is encumbered very heavily in Maryland due to environmental regulations and requirements. And that's especially true for a county like Talbot, that's on Maryland's eastern shore and practically surrounded by water. And so I think, you know, I just have to respectfully disagree with the court on that. I think the duration was both reasonable and shown to be necessary. And there was no evidence to the contrary that was adduced by the plaintiff, Clayland Farm. In other words, Clayland was unable to show at any point or time any evidence that the process took longer than it should have taken. I guess I don't know how to otherwise state it. I don't think there's a constitutional analysis for, you know, how quickly a political body can function or its processes should occur. I think that here there's just no evidence that it wasn't reasonable and necessary, and the burden is definitely on the plaintiff to prove otherwise. And I think that we showed, with respect to Bill 1229, that the reason the Tier 4 and Tier 3B categories were provided to Clayland Farm was because this property did not fit neatly within any of the other tier definitions provided by the implementation guidance issued by the Maryland Department of Planning, which particularly at the Joint Appendix 519 of 520, the guidance specifically says that if you are not in a designated growth area, but you have sewer service, that you can go into any tier. It specifically says that. And it says that properties that don't fit neatly within any tier on the next page can be placed in any tier. And if you are, it also says that if you're in an agricultural or forested area, as opposed to inside a village, or if it was actually or if you're in a village, you could be categorized as Tier 4. So, you know, the county attorney at the time went back and forth with the Maryland Department of Planning to ensure that he was interpreting it correctly. And Clayland's property was correctly put largely in Tier 4, and it was part of it was put in 3B, and the Maryland Department of Planning made no comment, meaning that it agreed with that. But more importantly, the tier had no effect on Clayland Farm because it didn't attempt to do anything. You know, I hear Mr. Gabler saying repeatedly that we prevented Clayland from doing this or that. We did not. Clayland never attempted, had a plan, never intended to do anything with its property. The only drawing that exists is the one that was created by its expert witness in this case, who came up with a site development plan so that their appraisal expert could then opine about the difference in value before enactment of the moratorium and after enactment of the moratorium. And really, this is key evidence here. Plaintiff's own expert appraiser says the property was diminished in value by $1.3 million due to the IDRs, but under the IDRs was still worth on the market $1.95 million. So even under the moratoria, Clayland could have sold its property for almost $2 million according to its own expert. How, under those circumstances, can they plausibly assert a regulatory takings claim? They can't. And so the district court properly ruled in favor of the county granting summary judgment on that claim. And as far as substantive due process, there's nothing there to indicate any of the factors that you would need to show a substantive due process violation. There's no evidence that Clayland was in any way targeted. On supplemental briefing in the district court, we came forward with maps of every single one of the 22 villages showing other large parcels that were affected by the moratorium and by the Bill 1229 tiers that were temporarily assigned, no longer exist. And we also provided a chart. Here's beginning at JA Joint Appendix 216, And that chart shows other large parcels other than Clayland that were similarly treated and affected by these laws, including the moratorium and the tiers. And so the factors you would need to prove a substantive due process claim simply did not exist here, and thus the district court properly entered summary judgment there on that claim. And I would just quickly throw in case your honors had any questions about the mootness, I think that was obviously a correct ruling by the district court that the claims challenging legislation that's no longer in existence were moot, and that any opinion on those would have been advisory in nature. Unless you have any questions.
All right, thank you, Ms. Shearer.
Thank you.
Mr. Gabler, you have some rebuttal time. You'll have to unmute your.
Okay, thank you, Your Honor. Briefly, a couple quick comments. The tier map legislation that was adopted by the state expressly says that tier 1 is for properties with sewer. It doesn't say tier 4 is proper, it says tier 1. And in this particular instance, when the map was first published, Talbot County got a comment from MDP. It was an informal comment that said, this is an improper designation for this property. Now, later on, they got another comment from them, but that was the initial comment was tier 4 is not appropriate where the property has sewer.
What was the follow-up comment?
There was no follow-up comment. I'm sorry, Your Honor. They said something like you've complied with the law or you've met the requirements or something more broad and sort of generic, but not specific.
It looked to me like the description of the property in tier 4 was exactly the way the property was being maintained and held out by Clayland. If I recall, the record shows that the children formed Clayland in 2002 and then set the property up in an agricultural status to get a tax benefit, and that the IRS then put a lien on it for 10 years and kept the property in that form. They got, over those years, they got a benefit, a tax benefit, which only ended in 2012. Isn't that right?
That's correct, Your Honor. It ended in 2012. And I believe they could have ended it earlier by some kind of a voluntary payment or something.
But that's even more indicative. If they could have, they didn't.
Again, the moratorium was approved in 2012, Your Honor.
I understand, but the complaint you keep advancing is that we had this valuable property, right? We wanted to develop it. We had all these plans, and they interrupted it with their moratorium. And the record doesn't seem to support that. Even if that were good enough, I don't know if that's good enough. It seems to me under Maryland law, you would have to take more concrete action to develop the property in order to get some kind of protected right.
Well, Your Honor, we've cited the U.S. versus Good case, I believe is the name of it, which stands for the proposition, if I recall correctly, that inaction does not bar a takings claim. And in point of fact, we don't have to. I
was talking about the substantive due process. If you want to talk about the takings claim, that's a little bit more difficult for you. I mean, the value of the land, there was a substantial value of the land even after the zoning. And
I understand that, Your Honor. And as far as I am aware, there's no threshold dollar amount that you have to meet. I understand Pulte said 83% was not enough, but when I read Pulte, that case also seems to say that the second and third factors under Penn Central did not weigh heavily in plaintiff's favor. In our case, we believe that is not we believe that it's the opposite. We believe that the character of this moratorium, I mean, what is Talbot County telling us? That for every 10-year planning and zoning cycle they go through, they're going to stop everyone from doing any kind of subdivision and development for the first 6 years? And then for the last 4 of the cycle, you get to try to, use it under the new zoning that they give you? And then they start that process all over again? And how long is too long? Would 8 years be too long? Would 10 years be too long? I mean, this was a 6-year moratorium that did nothing other than prevent people from using the rights that Talbot County gave to the property. Our client did not zone this property under Village Center. The county gave us the zoning. We had the right to use that zoning once it was conferred without being interfered or obstructed by an unlawful moratorium. I realize I keep going back to that point, but I think Judge Russell was very clear, and I agree with his discussion of that wholeheartedly, that this was a very concerning, if not explicitly unlawful regulation by the county. What was the purpose of stopping people from pursuing their development rights until they changed the zoning? What's the purpose of that? It's directly taking something away from people that the county gave to them in the first place. So our clients and any other person who had a similar zoning should have the right to go down, file an application, and pursue it until the zoning is properly changed. And in this case, the county reversed that sequence, and presumably if the court doesn't rule in our favor, they're going to continue to do that. And I would ask the court to focus on that moratorium. It's not a vested rights issue like in Sierra. It's a moratorium, and I agree that you shouldn't look at these moratoriums as if they were changes in the zoning or treat them like that. These are unlawful, an unlawful deprivation of our rights. Thank you.
All right. Thank you, Mr. Gabler. Well, thank you, both parties. It's our custom and practice to come down off the bench and shake hands with you, but I'm not quite sure where both of you are. Are you both on the Eastern Shore right now? Mr. Gabler, where are you located? Annapolis?
We're in Easton today.
Easton. And Ms. Sierra, where are you located? Unmute you.
I'm in Columbia, Howard County.
Columbia, Howard County. Well, it's a little hard for us to make the a visit down off the bench, but we would normally do that. We thank you for the arguments, and we'll stand adjourned.
Thank you.
Very much.
Thank you.
This honorable court stands adjourned until tomorrow. God save the United States and this honorable court.